Welcome back to Negligence Defenses. This is video 2 of 2, where we are going to continue our conversation of the 3 identified negligence defenses. Video 1, we covered contributory negligence and comparative negligence. That included comparative negligence that is pure, P-U-R-E, and comparative negligence that is modified. This video, the second of 2, is going to focus our attention on assumption of risk. Our attention for this video, assumption of risk. Up to this point, we have been evaluating the plaintiff's conduct through the lens of comparative negligence. The question has been whether the plaintiff failed to exercise care for their own safety, and if so, how much responsibility should be allocated to the plaintiffs. But now our inquiry is different, right? Because we understand that in law, there are situations where the plaintiff's conduct is not careless, but it's deliberate. The plaintiff sees the risk, understands the risk, and proceeds onward anyway. At common law, the kind of conduct was generally treated under a separate doctrine, right? That was under the doctrine of assumption of risk. It operated as a bar to recovery. So in other words, assumption of risk operated like this. If the plaintiff knowingly and voluntarily accepted the risk, the law treated that choice by the plaintiff as dispositive. So focus on what we are distinguishing. Comparative negligence, on one hand, asks whether the plaintiff failed to act as a reasonably prudent person, and if so, how did that failure contribute to the plaintiff's injury? Assumption of the risk is asking whether the plaintiff made a knowing decision to encounter the risk in spite of the risk. You know me, I like the rule of law, especially if we're teaching the rule of law, right? Fantastic. Under the comparative fault regime, we consider the following. When a plaintiff knowingly encounters a risk, how should that knowing conduct be treated within the broader allocation of responsibility? So follow me. We are in the world of comparative fault, right? We're in the world of comparative fault. That's our universe. When a plaintiff knowingly encounters a risk, how should that knowing encounter be treated within the broader allocation of responsibilities? Mind you, we are turning to the third restatement of torts. We are turning to the third restatement of torts. We are in restatement third of torts. We are in the section that's titled apportionment of liability. We are in topic 1, which is basic rules of comparative responsibility, section 3. All right, so we are in section 3. Now, what we see when we look at the third restatement of torts, we are told that a plaintiff's recovery is reduced when the plaintiff fails to exercise reasonable care for their own safety. The plaintiff's recovery is reduced when the plaintiff fails to exercise reasonable care for their own safety, right? That's comparative negligence. Now, let's look at comment A under this section. Comment A under this section. What do we learn from comment A? Well, I'm not going to read it to you, but comment A makes it clear that this section is not intended to be narrow. And you also note in comment A is where we have the abolishment of restatement second of torts 463, which was contributory negligence, right? So this section draws on and replaces restatement second torts 463. What is restatement second torts 463? That's the contributory negligence section. We've abolished it. That's why we're in the third restatement. Okay. This section applies to the standard of negligence, however defined, as it is in accordance with the plaintiff, right? This is our comparative negligence standard. This is how we look at the actions of the plaintiff and we make a determination as to whether or not the plaintiff was careless, whether or not the plaintiff acted below the standard of reasonable care that would be expected of a plaintiff in the same or similar circumstance. And if we find that that failure to adhere to the reasonable care standard of the plaintiff is a contributing factor to their harm, then the plaintiff's recovery is reduced accordingly. Got it? Right? That's what we talked about all of first video. That's what we talked about all of first video. So let's now turn to comment C, which is where we're going to find the conversation regarding assumption of risk, right? So comment C, relationship to implied assumption of risk and defendant's negligence. This section applies to a plaintiff's negligence, just like this section. This section applies to a plaintiff's negligence. This section also applies to a plaintiff's negligence, even when the plaintiff is actually aware of a risk and voluntarily undertakes it anyway. This is AKA our assumption of risk standard now. So what am I saying to you? I'm saying to you that the restatement third of torts not only abolishes contributory negligence, the restatement third of torts abolishes assumption of the risk as a stand-alone doctrine. Pay attention to the whole sentence. Restatement third of torts abolishes assumption of the risk as a stand-alone doctrine. What the restatement third of torts has done has relocated assumption of risk under the rubric of comparative fault. Okay? Feel free, take your time. You can go through it, stop it, rewind it, fast forward it, etc. Right? Thus, comment C is identifying a particular form of fault. This is not fault that is now grounded in the plaintiff's negligence as comparative fault. Assumption of risk is fault that is grounded in the plaintiff's conscious choice. See how we're measuring different things? Under comparative fault, we're looking at what is the role that the plaintiff played in the injury, right? Assuming that role is based in carelessness, okay? Assumption of risk is what is the role that the plaintiff plays in their injury, assuming their role is grounded in the plaintiff's conscious choice. Conscious choice. That's assumption of risk. Okay. So moving forward, understand assumption of risk under the relocation efforts of the restatement third of torts has two possible analytical outcomes. One doctrine, assumption of risk. Two, analytical pathways. There's a no duty outcome or pathway, and there is a still duty outcome or pathway. So let me slow that down. There is a no duty pathway. There is a still duty pathway. The no duty pathway is known as primary assumption of risk. The still duty pathway is known as secondary assumption of risk. Does it matter? Like night and day. Let's walk through how and why it matters. Before we assign consequences to the plaintiff's conscious decision, remember, assumption of risk, what are we looking at? Plaintiff's conscious decision, okay? Before we assign consequences to the plaintiff's conscious decision, we must focus on the analytical factors that must be considered under assumption of risk. We're not going to call these elements because the word element infers some pretty high level of rigidity. Instead, we're going to think about these analytical factors as analytical requirements, okay? They are still conjunctive, but here's the analytical requirements. Number one, is the plaintiff knowledgeable about the risk? Number two, does the plaintiff appreciate the risk? Number three, is the plaintiff's exposure to the risk voluntary? Number one, does the plaintiff know about the risk? Number two, does the plaintiff appreciate the risk? Number three, is the plaintiff's engagement of the risk voluntary? Again, this is a conjunctive. If any one of these three are missing, right, then it's not assumption of risk. Maybe something else, but it's not assumption of risk. It's not primary or secondary. Right? This three-piece analytical factors to be considered applies to both primary and secondary. Let's, right, if you've watched enough of my videos, I'm going to give you the pieces: knowledge, appreciation, voluntary exposure, and then we're going to give each one of them their own space so that you get to understand on a deeper level what knowledge is and how to recognize it, that you will understand on a deeper level what appreciation is and how to recognize it, and you'll understand on a deeper level what voluntariness is and how to recognize it. So knowledge, let's take a look at it. Knowledge is not just general awareness that there's some generalized danger involved, okay? The plaintiff must be aware of the specific risk that makes the activity dangerous. You've got to understand that the plaintiff has to have some specific understanding of that risk. Appreciation. Appreciation means that the plaintiff understands the nature and the seriousness of that risk, right? It's not enough to know something could go wrong, right? The plaintiff must grasp some level of maturity as to the nature and the seriousness of what could actually happen. A toddler understands that a hot stove is hot, right? Hot, hot, hot. They know that that's uncomfortable. They know that that hurts. They know that that's a feeling that they don't want to experience. So they know that a hot stove is hot. but do they appreciate it? Right? You're not going to have a toddler who's going to be able to tell you the seriousness of those consequences. For instance, the difference between a first degree burn, a second degree burn, and a third degree burn. Toddler will not be able to appreciate. Understand what I'm saying? So not only does the plaintiff have to have, number one, specific knowledge of the risk, right? There's got to, what specifically about this is dangerous. And number two, they have to appreciate it, meaning that it must go into an understanding of the nature and the seriousness of the risk. And then number three, engaging in the risk on the plaintiff's behalf must be voluntary, right? If the plaintiff had no reasonable alternatives, then that's not voluntary, which would then mean that assumption of risk doesn't apply. So let's do a quick review. In modern tort law, assumption of risk is no longer treated as a separate, independent defense. That's why we're not looking at restatement second of torts. That's why we're looking at restatement third of torts that has relocated assumption of the risk into the overarching frame of comparative negligence, right? Got it? And this is critical. Assumption of the risk is going to have two analytical pathways. One is going to be the pathway of duty, and one is going to be the pathway of fault. So that was a quick review. Two analytical pathways. I believe this is the third time that I've mentioned it. I've mentioned two analytical pathways. Now that's four times. One pathway addresses an inherent risk of the activity. Understand, I'm going to introduce the concept, and then we're going to go deeper into the understanding of the concept. And then we're going to go into the application of the concept. That's really generally how these videos progress. Let's introduce the concept. Let's explain the concept. Let's apply the concept. So here's the introduction to the two analytical pathways of assumption of risk. Pathway one addresses inherent risk. If it's inherent risk, the defendant owes the plaintiff no duty. That is considered primary assumption of risk. Number two, the second pathway is negligent risk. Negligent risk focuses on comparative fault, and that is considered secondary assumption of risk. All right. Primary assumption of risk. Ready? Let's go. Primary assumption of risk is a doctrine used to allocate responsibility between the plaintiff and the defendant. However, the primary assumption of risk is grounded in the first element of negligence. What is the first element of negligence? It's duty. So the mechanism of primary assumption of risk takes place and has its effect in the duty element. It occurs when the harm-producing risk is inherent or integral in the activity that the plaintiff is participating in. In other words, the harm-producing risk cannot be eliminated or removed from the activity without fundamentally changing the activity. If there is risk associated with the activity that cannot be removed without fundamentally changing the activity, then we say that risk is inherent or integral to the activity. If it's integral to the activity, that is primary assumption of risk, and that primary assumption of risk is not a function of the plaintiff's carelessness. It's not a function of the plaintiff's carelessness. It is a function of duty. Where am I trying to go? Plainly said, if the activity has the ability for harm producing risk, and if there's no way to restructure that activity to eliminate the harm producing risk without changing the nature of the activity, that's one, that the activity just has some risk. And if that's the case, we're no longer looking at carelessness, we're looking at duty. Where am I getting ready to go? I know you see it. If the risk cannot be removed by the defendant because the risks are inherent in the activity and the plaintiff knows about the specific risk, the plaintiff understands the nature and the seriousness of the risk, and the plaintiff voluntarily engages in the risk, what do you think? Yeah, the plaintiff is going to be barred from recovery. Why? Because if the activity is one that just has inherent risk that cannot be eliminated, then how would you hold the defendant responsible for having a duty to the plaintiff to not engage in a course that is going to create unreasonable risk for the plaintiff? You wouldn't. You wouldn't. Let's go through a couple more slides. I think I went through two. No, that's the second one. Okay. If the harm producing risk is inherent, meaning if it's integral to the activity, meaning if there's some risk of harm that's expected, or the risk of harm is inseparable from the activity, then the law is going to look at the defendant's duty to not increase the risk very differently, right? The law recognizes that the risk in this particular activity cannot be eliminated, or the risk in this particular activity cannot meaningfully be reduced without fundamentally changing the nature of the activity itself. Once that determination is made, then here's the legal consequence. The defendant owes no duty to protect the plaintiff from unreasonable risk of harm. Once the defendant no longer has a duty, what happens? I don't then get to identify the standard of care. What else? I don't then get to evaluate for breach of the duty. Why? Because I don't have a duty. What else? I don't then move to actual causation. What else? I don't then move to an analysis of legal causation. Wait, back up, back up one more. Remember, if there's no duty, there's no negligence claim, because all of the elements of negligence liability are required. And if I don't have the duty element, the claim dies. That's Cardozo. Remember? I'll give you a second to let that settle. You might have to stop and rewind. That's okay. That's the beauty of a video. There are limits to this no duty doctrine of assumption of risk. What are some of the limits? primary assumption of risk does not apply if the defendant increases the risk beyond the inherent baseline. So you can't have the defendant saying, okay, you're going to ride the super shocker, scramble you upside down ride. Great. There's some inherent risk in that. It's going to shock you and it's going to scramble you and you're going to be upside down. Okay. That's some risky behavior. Yeah. Yeah. Now, if I jailbreak it, let's just say, and I can figure out how to make this machine go twice as fast, right? Make it go faster than it was designed to go. Well, now I've just increased the risk. So I don't now get to say, if you get on that ride that I've jailbroken, you don't get to sue me if you get hurt because you assumed the risk of an inherently in a inherently risky activity. I don't get to say that. Does that make sense? The second limit is if the defendant acts recklessly or intentionally. The third limit is if the risk is concealed or not reasonably apparent. If the risk is concealed, right? There has to be some openness about the risk in order for the plaintiff to say, number one, I know about the risk. Number two, I understand the nature and the seriousness of the risk. And number three, I voluntarily do it anyway. If the risk is concealed or hidden, well, then the plaintiff cannot make a knowing decision to enter or engage voluntarily. Make sense? All right. You know me, I like steps. I'm the practicality proofer, right? It's got to make sense. If it doesn't make sense, then we can't use it. And if we have a tool that we can't use, well, that's what doesn't make sense. So what are the 4 steps in order for me to evaluate a primary assumption of the risk essay or multiple choice question? Great. Step 1, I have to identify the precise risk. Well, that makes sense. All right, that makes sense. Step 2, I have to determine whether that risk is inherent or not, because I've got to make a decision. I've got to make a decision. Is this one of those situations where there's not going to be any duty of reasonable care owed to the plaintiff by the defendant? Or is this one of those, no, there's some duty owed here, right? So I've got to determine if the risk is inherent, if it's integral with the activity. Step number 3, I have to ask whether the defendant increased the risk beyond what is inherent. Remember, defendant can't be jailbreaking the activity to make it better, but worse, right? And then number 4, I get to resolve the duty issue. What's the duty issue? Either the defendant has a duty or the defendant doesn't have a duty. Get it? Either the defendant has a duty or the defendant doesn't have a duty. If the defendant doesn't have a duty because the activity is inherently risky, no duty, no breach, no actual cause, no proximate cause, no damages, no nothing. The claim is done. All right. I've introduced you to the steps. Let's explain the steps in a little more detail. Step 1, identify the precise risk that caused the injury, right? This is not a general danger. You must isolate the exact harm producing risk that may materialize. Get it? It has to be specific. It has to be precise. You see, I have in italics, exact risk. Perfect. Step 2, determine whether that risk is inherent in the activity. So I've got to identify the precise risk. Number two, I have to determine whether that precise risk is inherent in the activity or not. And we talked about inherent, right? We're asking whether the risk is part of the activity as it is ordinarily conducted. If eliminating the risk would fundamentally change the activity, then that's a strong indication that the risk is inherent. Step three, I'm asking whether the defendant increased the risk beyond what is naturally there. What am I looking at? Did the defendant introduce additional danger beyond the ordinary scope of the activity, right? Did the defendant increase the risk? And then step number four, we get to resolve the duty question. And this is where our payoff is, right? If the risk is inherent, then the defendant owes no duty, which means the case ends there. If the risk is not inherent, let's say that the defendant increased it, right? Then that means we do have a duty. And then we're going to move through the additional requirements to establish negligence liability. And if the plaintiff entered into that harmful situation knowingly, with appreciation, voluntarily, then we will exercise what we learned in slide one, which is how to apportion the injury between the plaintiff and the defendant. Get it? Let's apply it now. You've been introduced to the algorithm. We've explained the steps of the algorithm. So now let's apply it. We're going to apply that with the Murphy v. Steeplechase Amusement Company case, also known as the Flopper case, Flopper, Flopper case. What are some of the facts? Facts. Plaintiff voluntarily chose to ride an amusement park ride named the Flopper. The ride is designed to flop you, right? It's designed to knock you off balance. What's the precise risk? The precise risk is of falling, right? Falling. Well, falling, if the risk is that you're going to fall, is it fair to say that falling carries with it some potential expectation of injury? Yeah? Okay. Now, the purpose of the ride is to make you fall down. So the falling, the precise risk issue is the purpose of the ride. And the plaintiff was able to observe the ride before participating in it. So the plaintiff had a great knowing and opportunity to understand the seriousness of this potential harmful activity, right? There's no hidden or concealed dangers in the ride. There's no allegation that the defendant increased the danger of the ride. And of course, the plaintiff was injured when they were thrown from the ride. The injury resulted from the very risk that defined the activity. What was the injury? He broke his knee. What's one of the things that you do when you get slammed down? It's very possible that you can break your knee, right? The defendant operated the ride as it was intended. So what's the issue? Under negligence law, does a defendant owe a duty? Remember, primary assumption of risk. We're trying to determine whether or not the defendant owes the plaintiff a duty. So here's my question. Under negligence law, Does a defendant owe a duty to protect a plaintiff from injury when what? When the plaintiff voluntarily participates in an activity whose inherent design is to create the very risk that causes the very injury that the plaintiff suffers. Yeah. Oh, let's take a step back to the past. Let's take a step back to the past. You remember the fact element chart? Take a step back to the past. So, what's the fact? The fact is the ride is designed to knock the riders down. Where did I get that fact? I got that fact from the hypo. What element, or since we're not really calling them elements, what analytical factor does that connect with? Well, that connects with the inherent risk factor, right? How did the court evaluate that pairing, that fact element pairing? The court's evaluation was that risk is a central feature of the amusement park ride. Why does it matter? Because the risk defines the activity. What would be the outcome? No duty. Well, let's look at another fact. What's another fact? Another fact is that the plaintiff voluntarily rode the ride, right? You see the pattern? What element or analytical factor does that connect with? Voluntariness. What's the court's evaluation? Fully voluntary participation. There was no coercion, there was no misrepresentation, there was no fraud. Yeah, right. So, why does that matter doctrinally? Because it satisfies the analytical factor of voluntariness. What does that mean? It's going to mean that that supports no duty. Let's do one more. What's another fact? Another fact is instead of saying the risk is obvious, which is a bit of a conclusion, I could have stated better that the plaintiff had observed others ride the ride. So what? Well, by doing that, we support the analytical factors of knowing precisely what the risk potential is, which is to be knocked down, and appreciating it because as I'm watching other people get knocked down, I'm watching the potential seriousness of what that being knocked down by that ride means. How did the court evaluate that? That the plaintiff was aware of the danger. Why does it matter? There's no hidden risk, right? So I've outlined my facts. I've now wedded my facts with my analytical factors, because we said we weren't going to call them elements, we're going to call them factors or analytical factors, right? What identifying the precise risk, falling down, determining whether the risk is inherent. Yeah, that's the whole purpose of the ride. Asking whether the defendant increased the risk. There's no indication that that was done. So now we get to resolve the duty. So I've got my facts. I have my issue. I applied my facts. I wedded my facts to the element. I've looked at the evaluation and I've explained why it matters doctrinally. So whether this is a multiple choice or an essay, I have a process to resolve it. Ultimately, how did the court rule? What was the court's rule of law that was announced? A defendant owes no duty to protect a plaintiff from risks that are inherent, obvious, and integral to an activity voluntarily undertaken by the plaintiff. Boom. Is that not comment C of the restatement third of torts, section 3? Right there. That's the rule of law that we take away. Get it? What's the doctrinal takeaway? As observed in this case, primary assumption of risk applies when the plaintiff's injury results from harm-producing risk, right? That constitutes the defining feature of the activity itself. In other words, the risk is integral to the activity, right? In that situation, the defendant owes no duty of reasonable care. And if there's no duty, there's no liability. Done and done. Get it? We worked through it. Oh my goodness. In 41 minutes, we've gone from the introduction of assumption of risk. We've talked about how it has been replaced in the restatement second with the restatement third by removing assumption of risk as its own independent doctrine and relocating it as under the umbrella of comparative fault, right? We've talked about the primary and the secondary. Primary is looking at the inherent nature of the activity in order to determine if the plaintiff is going to be barred from recovery or whether or not the plaintiff is going to be responsible for some proportion of the recovery under comparative fault. I've got to, number one, establish that the plaintiff knows, appreciates, and voluntarily engages with the risk of harm. And for primary, I have to establish that the risk is integral to the activity. If so, that means that the defendant owed no duty. And if the defendant owes no duty, that means there's no liability. And if there's no liability, that means that the plaintiff takes nothing. Oh my goodness. Look at that. Okay. One more example of primary assumption of risk, because I signed only 2 cases. So let's get through the second case. The second case is styled Knight v. Jewett. Knight v. Jewett. What's going on in Knight v. Jewett? Well, we've got some facts. Plaintiff and defendant participated in a touch football game. Cool. The game involved physical contact, competitive play. It's football. Defendant collided with the plaintiff during play. It's football. Plaintiff injured her finger during the collision. Plaintiff alleged that the defendant acted too aggressively. That, right, too aggressively. What? Right? It's like trying to thumbtack Jello to the wall too aggressively. What are we saying? Because what do we learn from the facts of the case? There's no evidence of any intentional injury. So there's no evidence that the defendant intended to hurt the plaintiff's finger. There's no evidence of reckless conduct. So there's no recklessness. Physical contact was expected in the activity. These are the facts that we're pulling from the facts of the case. The defendant did not introduce a risk outside of the game's ordinary conduct. In other words, the defendant was found not to have increased the danger of the activity, and the injury rose from the manner in which the game was played. Okay, well, we've got the facts. Well, let's see what the legal question is that we're going to use these facts to answer. Under negligence law, does a defendant owe a duty to protect a plaintiff from injury when the alleged harm results from the conduct within the ordinary scope of the game? We could actually end that issue statement right there, right? I added a little bit because I wanted for you to see that what we're really doing is we are making a distinct separation between whether or not a duty is owed by the defendant, which is primary assumption of risk, or whether or not we're going to compare the liability of the plaintiff to the liability of the defendant, which is secondary assumption of risk, provided in both of those situations, the plaintiff acted knowingly, with appreciation, and voluntarily. Okay. All right. Let's go. Don't you love the tables? I love a table. I love a table. Let's identify the facts. Let's wed the fact with its counterpart in the element. Let's see what the court evaluated that coupling to be, and let's see why that coupling matters doctrinally. Again, we're only going to go through a couple of them. What is the activity? Football. Got it? So participation in football, plaintiff and defendant, the element is, well, what is the analytical factor? Voluntariness? Really, right? What is the court's evaluation? It's a sport that has some inherent risk. If I take out the risk, then I've changed the structure of the activity. I've changed the structure of the activity. What happened? There's some physical contact. Is that part of the activity? Yeah, it's inherent in the activity, right? So the court says what? Well, this is just a normal feature of the game. Why does it matter? Because the risk belongs in the activity. Get it? Get it? There's a finding that there's no reckless conduct. So how does that square? That means that the defendant didn't do anything to increase the risk. It was within the ordinary play. What does that mean? The risk is inherent. You can create your own table. You can do this for multiple choice, more specifically essay, because each one of these rows is going to become a sentence in my analysis. This is how I wed the fact to the element. I explain what the coupling is, and I explain how or why it matters doctrinally, which leads me to a conclusion. Okay. What's the doctrinal takeaway? As demonstrated tonight, when the plaintiff's injury arises from conduct that falls within the ordinary scope of the activity's inherent risk, the defendant owes no duty to the plaintiff. If there is no duty to the plaintiff, what? No liability. Got it? All right, fantastic. Let's move to secondary assumption of the risk. We are cooking with fire. Let's move to secondary assumption of risk. What's going on in secondary assumption of risk? Secondary assumption of risk is used to allocate responsibility between the plaintiff and the defendant. What am I doing? I'm setting up a comparative negligence situation. How is this different from the comparative negligence in video one? It's different because you're going to see that the plaintiff is going to engage in a activity that has some risk involved, right? But we're going to be able to show that the plaintiff knew about the risk, appreciated the risk, and, right, voluntarily participated even though they know that there's risk, right? Got it? Got it. That's assumption of risk, which falls under what? The larger umbrella of comparative negligence. So assumption of risk is a specific type of comparative negligence. Assumption of risk doesn't go to all comparative negligence because it's just one form of comparative negligence. All right. Assumption of risk defined. The doctrine is used to allocate responsibility between the plaintiff and the defendant, operates at the level of breach, right? We're looking at fault in this one. It occurs when the harm producing risk is created by the defendant's negligence and the plaintiff knows and voluntarily encounters the risk anyway. Get it? The risk could have been eliminated or avoided had the defendant not breached their duty. But even though the defendant breached their duty, acknowledging that the defendant breached their duty, the plaintiff still decides to go forward in the activity. So now, how are we going to allocate? How are we going to apportion this responsibility between the defendant and the plaintiff? Here's the rule for secondary assumption of risk. If the harm producing risk is created by the defendant's failure, so we've got some liability on the defendant, right? We've already got liability. On the defendant's failure to exercise reasonable care, the defendant owes a duty. Got it? Right. The plaintiff's conduct is evaluated under comparative fault because even though we've got a breach on behalf of the defendant, the plaintiff is assuming some risk because they're choosing to go forward. That choice to go forward in the face of a clearly risky situation because the defendant has breached their duty does not bar the plaintiff from recovery, but it is going to require the plaintiff to accept their proportionate share of the liability, right? So again, secondary assumption of risk does not eliminate liability. That's primary assumption of risk. I've got an algorithm, a step-by-step for secondary assumption of risk as well. How does it work? Step one, identify the precise risk. Ooh, well, that sounds like primary assumption of risk. Okay. Step two, determine whether the risk that's created is the result of defendant's negligence. That's where it's different. See, that's where it's different. For primary assumption of risk, I am trying to evaluate if the risk is inherent in the activity. For secondary assumption of risk, I'm trying to determine whether or not the defendant has some liability. Right. Step three, both of them got to determine, did the plaintiff act knowingly, voluntarily, with appreciation? Step four, I'm going to resolve the fault. Got it? Step one, identify the precise risk. Again, this is not a general danger. Step two, determine whether the risk was created by defendant's negligence. In other words, I'm going to ask, is this a risk that should have been avoided by reasonable care of the defendant? If yes, I've got a duty, then I keep moving. Step three, ask whether the plaintiff knowingly and voluntarily encountered the risk. Did the plaintiff understand the specific danger? Did the plaintiff choose to proceed anyway? And step four, I'm going to resolve the fault, which means because there's a duty, I'm going to compare the plaintiff's conduct with the defendant's negligent conduct, and then I'm going to allocate liability accordingly. Here's an example. During a busy evening rush, a grocery store's commercial refrigeration unit in the dairy aisle begins leaking water. Okay. The leak has been ongoing for at least 2 hours. At 4:30 p.m., an employee reported the leak to a floor supervisor. The supervisor instructed the staff to put a sign out. But the supervisor didn't assign anyone to clean up the water or to attempt to fix the leak, but put out one of those little yellow, right? You've probably seen them in the grocery store, careful, floor wet. Mr. Wells uses them when he's polishing the floors here, right? He'll put a sign out, slow down, be careful, right? So a single yellow caution cone was placed near the edge of the puddle, but the water continued to spread across the aisle. Sounds like we have a continuing leak. No mats were placed and no effort was made to block off the area, and we already know that nobody cleaned up the water. This is at 4:30. By 6:15, the puddle extends several feet across the very high traffic walkway between the milk and eggs in the dairy section, right? These are some additional facts that we know. The plaintiff is a regular customer of the grocery store. They entered the aisle get some milk. That's the dairy aisle where we have the leak, and now for over 2 hours, a puddle. The plaintiff notices the puddle forming, right? And she sees that it's coming from the leak in the dairy case. Okay. The plaintiff looks directly at the caution sign. Okay. The plaintiff watches another customer walk around the spill. Okay. Plaintiff decides, for whatever reason, looks slippery, but I think I can make it through it. I'll just walk slowly. I'll take my time. I'll go slow. I think I can get through it. The plaintiff attempts to step carefully through the water with her shopping basket. She's being careful now. She's being careful. As she steps into the puddle, her foot slides forward. She loses balance and falls, sustaining a fractured wrist. Here's some additional facts. The lighting in the store is bright, so it's unobstructed. And we know that she saw the leak and the puddle because the facts tell us that she saw the leak and the puddle. The puddle of water is clearly visible. We know that because the facts tell us that. There's no emergency or time pressure requiring the plaintiff to proceed through the puddle. We know that because there's an absence of facts that indicate otherwise. Okay. Alternative routes through the store are readily available. Well, what we know is this plaintiff watched another customer walk around the puddle with no incident. Why this plaintiff chose to walk through the puddle? No. But we also know that there's a store policy that requires the immediate cleanup of spills, not just putting out a sign. So what does that very last one, that store policy? Well, it seems to indicate that the plaintiff it seems to indicate that the defendant breached their duty. Not a problem. Why are we using assumption of risk? Because the plaintiff knows the duty, appreciates the duty, voluntarily goes through and engages with the risk of harm anyway. Do we use that to punish the plaintiff and say, you get nothing? No. But we do use that to establish that you're going to, plaintiff, have to accept your proportionate accountability in the injury. Step 1, identify the precise risk. What's the precise risk? Slipping on a known visible puddle of water by a leaking refrigeration unit. What's the risk? Risk is I can fall down. What happens when I fall down? Various kinds of injuries, but that's the precise risk. Step 2, determine whether that risk was created by the defendant's negligence. So what am I asking? Could this puddle and potential spill opportunity been avoided? Sure, it could have. Absolutely. How do we know? Well, we know that the leak has persisted for at least 2 hours because the fact told us that. We know that the store had actual knowledge because the employee reported it. We know that the supervisor made a conscious decision to do something, which was put out the sign, but they didn't make a decision to fix it or clean it up. Right. So these are all facts that we know that would indicate that this risk could have been avoided if the defendant didn't breach their duty. What do we establish? That the defendant had a duty. Step 3, we ask whether or not the plaintiff knowingly and voluntarily encountered the risk. Well, how do we know? Well, let's look at our facts, right? Plaintiff saw the puddle. The light is bright and unobstructed. Plaintiff looked at the sign. Plaintiff observed another customer avoid the hazard just by walking around it. She acknowledges the risk by saying, ooh, this looks like it might be a little bit slippery, right? So that's my step 3. Get it? That's my step 3. I did it here in a different format because it might be a little bit easier to see, right? A little bit easier to see. But my step 4, what is the resolution? Well, the plaintiff chose to proceed even though she recognized we've got a serious issue here, right? And we know that the issue is precisely identifiable. What does that mean? We've got a duty. We know that the defendant breached the duty, but we also have a rather recalcitrant, for lack of a better word, plaintiff who says, I see it, I understand it, but I'm going to attempt it anyway. What does for do? For means, for doesn't mean that we're going to dismiss the plaintiff's claim. For means that we're going to apportion the responsibility, right? We're going to apportion the responsibility. That's our comparative negligence. How do we do that? That's all of slide 1, right? We're looking at the defendant's conduct. The defendant created the condition. Yep. The created failed to remedy the condition. Yep. The defendant ignored the safety policy. The safe alternative to avoid the risk, but chose to engage the risk anyway, right? We call it contributory fault, but we know we're not talking about contributory negligence because that's been abolished. But she did, the plaintiff, contribute to this injury, right? This was conscious risk taking. And for that, we're going to have to apportion, some fault. This isn't a bright line, right? This isn't scientifically precise, but it's enough for us to gauge if this is a pure comparative fault jurisdiction. Then plaintiff is going to walk away with 65 to 75% because she didn't cause 65 to 75% of it, right? If this is a 50% modified, plaintiff is still going to walk away with her 65 to 75% proportion because she did not exceed 50%. If this is a 51% modified, the same. Plaintiff is still going to walk away with her 65 to 75% because she didn't exceed 51%. Got it? When the defendant creates a risk that reasonable care would have prevented the injury, the law does not excuse it, but the law says we need to apportion the percentage of liability when the plaintiff proceeds knowing, appreciating, and voluntarily engaging with the harm that is the result of the defendant's negligence. Got it? Questions? That's assumptions of the risk. We close the book on that module. Next module is going to be several liability. Not going to spend a lot of time on joint and several liability because number 1, it's been abolished in the 3rd restatement second of torts. And number 2, most jurisdictions have abolished it, like contributory negligence as well. So I hope to see you on the next series of slides.